Your Honor, ladies and gentlemen of the jury, I am here today to demonstrate why the evidence collected by the fire investigator assigned to this incident should be considered in this case. It is the duty of every fire department, regardless of size, to appropriately determine the cause of any fire to the best of their abilities. In doing so, our department employs trained and certified fire investigators to carry out this duty. It is because of their experience, knowledge, and training that I can rely upon their findings in any such case that is presented. The incident in question at 614 May Street was an unfortunate one, to say the least. Thankfully, no persons were hurt in this incident. However, there remains substantial evidence to argue a charge of arson against the property owners. The particular incident was dispatched with only a first alarm assignment, which meant a limited response of apparatus and personnel. The first crew on scene stated that they had fire conditions within the residence, specifically in the area of the living room near the TV. The fire was quickly extinguished per standard operating procedures, and search and rescue operations were canceled due to the arrival of the homeowners who stated that no one was inside the residence. During normal operations, fire department personnel would remain on scene to maintain a chain of custody of evidence within the residence for fire investigators to examine, as well as to secure the property on behalf of the homeowner to ensure that no further loss continues as a result of the fire or damages caused to the structure by forcible entry operations required to gain entry into the structure upon arrival. However, in this case, exigent circumstances are present which required the fire personnel on scene to leave the incident and respond to another that was occurring not far from where they were. Best practices determine that the closest fire crews to any incident shall respond as quickly as possible to mitigate any dangers, and this was no different. The second incident also had a report of 3 children trapped inside a burning structure, which greatly increased the need for immediate mitigation from fire crews, regardless of their current assignment, as well as increased the complexity of the incident, which required a full alarm assignment that included the crews present at 614 May Street. Because of these factors, it was both prudent and emergent that the crews who were still on scene at May Street respond to the second incident despite the potential break in the chain of custody of any evidence that was present at the initial scene. It is also because of this required response to an additional incident that proper overhaul could not be performed by the fire suppression crews who were on scene. The intent of overhaul is to determine that no further dangers are present on the scene of the fire and that any persons inside the structure can safely be inside. Without this having been performed, it can be assumed that only the trained fire department personnel would be able to determine whether or not those safe conditions existed. Surely, without any overhaul having been done before the departure of the suppression crews, it would not have been proper for an investigator to enter the scene at that time. So, a delay in response from them would have been warranted anyhow until overhaul was completed adequately enough for them to enter. In the absence of such determinations from the incident commander, the responsibility falls on the investigator to make that determination, which they did on this particular incident while performing their duties. I should mention that the investigation took place as soon as reasonably possible by the fire investigator, a matter in which previous courts have upheld as constitutional. Furthermore, when our investigator arrived, they performed their investigation in a standard manner by photographing all aspects of the structure, both exterior and interior. During their investigation, they discovered pertinent and obvious evidence at the scene of the suspected origin of the fire, which led them to the belief that arson was involved. Further circumstantial evidence is being presented, which includes what appears to be staging of non-operational but frequently used items throughout the house, as well as a lack of any personal belongings that would typically be found in a residence that is being actively lived in by a family. While this secondary evidence does remain circumstantial at this time, it is not irrelevant. In addition, fire investigations are not performed solely with the specific intent to determine if a crime has been committed. It is only in the course of an investigation in which evidence of a crime is found that it becomes a criminal matter. Otherwise, the information collected is only recorded in the National Fire Incident Reporting System for research purposes to avoid future incidents of a similar nature. I'd like to take a minute to present some text from a previous court case that I find relevant. In the case of Michigan versus Tyler in 1978, the U.S. Supreme Court stated, "Fire officials are charged not only with extinguishing fires, but finding their causes. Prompt determination of the fire's origin may be necessary to prevent its recurrence, as through the detection of continuing dangers such as faulty wiring or defective furnaces. Immediate investigation may also be necessary to preserve evidence from intentional or accidental destruction. And, of course, the sooner the officials complete their duties, the less will be the subsequent interference with the privacy and the recovery efforts of the victims. For these reasons, officials need no warrant to remain in a building for a reasonable time to investigate the cause of a blaze after it has been extinguished. And, if the warrantless entry to put out the fire and determine its cause is constitutional, the warrantless seizure of evidence while inspecting the premises for these purposes is also constitutional. Lastly, I find it quite curious that the homeowners returned to their property some time later with an attorney present. This isn't common. Most often they return on their own, or with friends or family to assist with gathering personal belongings, which would be required for their continued living after a fire has destroyed their primary residence. As stated before, there were no personal belongings in the residence to recover, which makes me question the necessity of having an attorney present at that time. Certainly, if after the arson charges had been brought upon the homeowners that they obtained legal representation, that would be expected and well within their legal rights to counsel. It is for all of these reasons that I maintain that the evidence was properly collected in a timely manner, to the best of the department's abilities despite the exigent circumstances, and it should be considered in this case and not dismissed under a violation of the Fourth Amendment.